With us now, CNN Chief Law Enforcement Analyst John Miller, CNN Legal Analyst Elliot Williams, and Defense and Trial Attorney Misty Marris. Elliot, you're just joining us now, having watched this. What jumped out to you about this hearing and the legal case, the pretty novel legal case against the father of this shooter?
Absolutely. Now, John, this was a very straightforward legal hearing, this type of initial appearance where an individual is advised really of the rights he has in the system. You have a right, no matter who you are, no matter how heinous your crime is, you have a right, number one, to an attorney. You have the right to remain silent. You have a right to confront witnesses against you. And these are things that someone has to be advised of before he makes any sort of decision as to whether to go to trial, whether to plead guilty, or whatever else. And so it's very straightforward. Now, to the novelty point, now we are aware of this case in Michigan involving the Crumbleys earlier in the year, in which parents were convicted of the conduct of their child in a school shooting. That is in the ecosystem now, this idea that parents can be charged for their negligence, whether it's getting in allowing their children access to firearms or not safely securing them. And perhaps we'll see more of it here. I am really curious as to what further evidence the Georgia Bureau of Investigations and Law Enforcement is going to come forward with that we knew or have found out about exactly how negligent was this parent in a manner that sort of will justify the charges they brought against them, because they are incredibly serious charges, far beyond this sort of accidental killing. When you're starting to talk about murder, at least under Georgia law, it's obviously a very serious offense.
Yeah, and we heard the judge say he faces up to 180 years imprisonment for each of the charges total. I do want to get to you, Misty Marris, because I am curious about one of the charges, the 8 charges of child cruelty. How does that play into that? Because we did have 2 students who were shot and killed by the alleged shooter, the son of this father.
Correct, Sarah. We have 2 that were shot and killed, and we know that that's the basis for not only the child cruelty charges, but also the charges of second-degree murder. So that's part of those charges. The others relate to the other minors who were injured. Remember, we have 4 deaths, but we have other injuries and those that are being hospitalized due to their injuries who are also victims in this case. So those child cruelty charges relate to those. And again, all of these charges, as was pointed out, we've seen how the manslaughter charges play out. But when we're talking about these murder charges and child cruelty charges, and that conduct against the father being that of another person, his minor son, that is a new and novel legal theory. So it's going to be interesting how this plays out, and especially if he does opt to have what's called a preliminary hearing. You have a bit of a mini trial there. And I could see the father in this case saying, yes, let's have a preliminary hearing to see if there's probable cause to support these higher level charges of second-degree murder. We will learn a lot during that process, because that's almost like a mini trial with a different legal standard of probable cause. So that's going to fill in the gaps that we have in what we've learned from this investigation, from that May 2020 meeting to the present day in this tragic incident.
John Miller, obviously the investigation does continue. What evidence do you think that they may have found that we have not yet learned about, or what type of evidence?
So what we saw today, what we actually saw Mr. Gray signing were the warrants for these charges, the warrants for his arrest. What we haven't seen is the affidavit behind that warrant, which gives the probable cause for these charges. And that, because we haven't seen it, could contain things that we're not aware of. So what are we aware of? We're aware of the shooting, we're aware of the guns in the house, we're aware of the allegations that they weren't security had access to them. But the things that they could see, and we learned some of this from the Crumbley case, is what's contained in emails, text chats, what's contained in this boy's computer, what is contained in the communications to, in this particular set of charges, the father, from the mother, from the grandparents, from the school, from others that are going to be demonstrative, possibly, of his awareness of the fact that this is a child in crisis. The first day of school, he went out to see the counselor because of anxiety. The second day of school, of course, we have the shooting. But in CNN's own interviews with various relatives, they're saying it was obvious that he was a child that was going through crisis. So all of that can factor into the what did he know and when did he know it part that will be an additive to would a reasonable person have not secured these weapons, and was this negligence that could lead to serious injury or death?
It really, watching this just once again, seeing that child go into court so small, seeing the families have to sit there and look at what's happened, knowing that they will never see their loved ones again, and then seeing the father come in. These are remarkable images. They tell a story of what America has been going through for a very long time, but it also tells a story of the change that law enforcement is making when it comes to school shootings. Now parents are really in the legal bramble, if you will, of all of this, and that's a huge change in our society. Misty Marris, thank you so much, John Miller, and to you, Elliot Williams, as well.